My question is, why a council has repeatedly stated that a lack of completed diary sheets limits what action it can take, yet residents have reported odour for nearly 2 years through multiple channels. Does the council accept that relying on a flawed diary sheet system has allowed serious harm to continue, and that hiding behind administrative failure amounts to the council avoiding its own responsibility, especially given that even a smaller number of affected residents should have been sufficient to trigger earlier intervention?
Thank you for that. Councillor Bowman, would you like to respond?
Yes, thank you, Mr. Mayor. Diary sheets act as legal witness statements and represent the gold standard method used by local authorities across the country to collate robust, court-accepted evidence of unwanted odours and the impact they are having on people's daily lives, both at home and in the place of work. The gathering of complaint numbers alone is not sufficient. By detailing the frequency, duration, intensity and impact of the odour, diary sheets help the council determine if the legal threshold for statutory nuisance has been met. The council needs to prove that the odour is causing an unreasonable and substantial interference to individuals, and in capturing specific examples of how the odour affects daily life, diary sheets are an essential component of this. Diary sheets are, however, only one step in the evidence gathering process. Diary sheets evidence must be verified by officers in order for them to be able to take a case forward to court. Officers must therefore be able to undertake odour monitoring at residents' homes in order to validate the evidence submitted. Validation visits also allow officers to experience the odour impact themselves, so they are therefore in the strongest position possible to demonstrate the impact in court. While the council has now received a reasonable number of diary sheets from residents, the number is substantially lower than they would ordinarily be expected given the number of complaints received. Further, the number of validation visits accepted by residents who have submitted diary sheets is extremely low, which means we must continue to gather evidence. As a means of addressing this, we are currently working closely with residents who have shown a willingness to both submit diary sheets and accept validation visits in order to allow for the collection of quality evidence. The council does, however, continue to encourage all residents impacted by the odour to contribute to the process. Residents should not assume that the council is receiving sufficient evidence from others, as this is not the case. Thank you.
Thank you, Councillor Bowman. Jessica, if I may call you that, you have the opportunity to raise a supplementary question.
Okay.
This must arise directly from the original question or from Councillor's reply given. So do you wish to do that?
Yes, please. Okay. Given the council's position that diary sheets limit statutory nuisance action, why has lease enforcement not been used as an alternative route? Can the council confirm this evening whether the operator has been fully compliant with all its lease obligations?
Thank you. Councillor Bowen.
Yeah, I will give you a written reply on that.
That's not really answering the question directly, though.
No, she didn't do that last time.
Can't you? You must know. So, can you not give us a straight answer? Has Transways...
I will give you a written reply. It's my prerogative to give a written reply.
Does it actually reply to my question? Does it give an answer, yes or no? It's simple. It's a simple question. It relates to my other one. So I can't get a direct answer to my question from... No?
A written reply so I can go into more detail.
Okay.
Thank you. We have a second question which has been submitted by
the Environmental Protection Act of 1990. For clarity, would you confirm the following? That the Council considers the statutory nuisance provisions in the 1990 Act to be its only legal basis for taking enforcement. That no breach notice has been issued under Clause 8 of the lease dated the 20th of August 2014, despite the tenant's duty under Clauses 5.16 and 5.17 to use best and reasonable endeavours to prevent nuisance, and despite over 1,500 complaints from residents. And 3, that the Council has not sought indemnity under Clause 6.6 of the lease of nuisance-related harm, and that having extended the lease by deed of variation on the 24th of March 2021 to permit tipping until the 31st of December 2027, and having agreed rent increases linked to the waste volume, the Council nonetheless maintains it bears no legal responsibility for the nuisance reported by the public.
Thank you, Doctor. Councillor McKay, would you like to respond to that?
I've actually addressed that question to Councillor Vincent.
Because it relates to the lease, it does come under my portfolio as resources portfolio holder, so I'm happy to take the question if you're happy with that.
If that's the only way I'm going to get an answer, I am, but I would like an explanation as to why a question that I've addressed to Councillor Vincent isn't being answered by him.
Okay, well, I'll take the question for now, we can come back to that. Thank you for your question, Dr. Neal. As a council, we completely agree that the odours from Jameson Road site are unacceptable and cannot continue. We understand that this smell is having a significant impact on the local community, and we are committed to bringing about a long-lasting resolution as a matter of priority. We have and continue to take legal advice from external legal professionals, including solicitors and barristers, to answer legal questions, advise the council on the best course of action that the council can take and when that action can be taken. Before I answer your question specifically, I need to stress that any legal advice which we have received or expect to receive in relation to this matter is subject to professional privilege. This means the legal advice is confidential and it cannot be disclosed. Unfortunately, I am unable here tonight to answer all your question in the detail that I would like and that the question deserves. However, I will try to answer it as best I can at this point. Point one, the Council is fully aware of all its statutory powers and its rights and remedies under the lease and deed of variation. We continue to work closely with external legal advisors on all options and best courses of action available to us at any point. There is an ongoing investigation into operations at the site. Unfortunately, I'm unable to disclose any detailed information on this at this stage. I do appreciate, however, that this investigation has been going on for some time now and officers are chasing this final report. As Jameson Road is a permitted site, the responsibility for the permit lies with the Environment Agency. The Council does, however, continue to meet regularly with the EA and to apply as much pressure as possible to help drive forward their investigations. Points 2 and 3 I'm going to take together because it's the same answer. It's correct that we have not yet served a notice or sought indemnity in respect of a nuisance as per our professional advice. Any action under those provisions would be considered in light of the facts and legal advice at the relevant time. And in respect of point 4, the deed of variation amended certain commercial and definitional terms. It did not transfer operational responsibility for compliance or nuisance from the operator to the Council. These responsibilities lie with the operator. The Council is continuing to explore its options as the local authority and landlord. It is working closely with the EA and Lancashire County Council to ensure a joined approach to the regulation of activities at this site. Dr. Neal, I do appreciate the frustration and anger felt by residents in here tonight and those who are not here. The smell, it is unbearable and no one should be having to live with it. With spring finally here, I don't want any children in Wyre not going out to play or any elderly residents not taking those vital walks or even residents not opening windows because of this smell. It has gone on for too long and I know it feels like nobody is doing enough to stop this once and for all. Please rest assured that this council is committed to getting a resolution to this and it's across the chamber. We have officers who are dedicated to dealing with the ongoing investigations and issues at Jameson Road site. We are in constant talks with legal, the Environment Agency and Lancashire County Council and other professional advisors to ensure we are doing as much as we can as soon as we can. In respect to statutory nuisance, we have had numerous complaints, but without sounding like a broken record, we need the diary sheets and we need residents to let officers come to their properties and witness the smell. We now have a drone monitor which can detect hydrogen sulfide in the air and it's really good evidence for us. It's what we need, evidence that we can use in a courtroom that can prove that this odour is impacting on the normal enjoyment our residents have in their properties. We're committed to getting this evidence with officers now engaging in enhanced monitoring and being available around the clock to come out and witness the spell, but we still need residents to come forward and work with us on this. And thank you for your questions and coming in tonight.
Thank you, Councillor McKay, for a detailed reply. Dr. Neil, you obviously aware that you've got the opportunity to raise a supplementary question if you wish, but it must arise directly from the original question or the reply given. Do you wish to?
Of course. So, Councillor, may I ask, where a landowner receives rents from operations on its land, has full knowledge that those operations have caused repeated nuisance to residents, and holds legal powers under a lease to restrict or terminate those operations, but chooses not to, do you accept that such a landowner may in law be deemed to have adopted or authorised a nuisance and may therefore be liable for it? That is exactly what the court found in Sedler Denfield versus O'Callaghan in 1940. Where a landowner knows of a nuisance and fails to stop it, it is treated as having continued it. It was confirmed in Lippiat versus South Gloucestershire Council 2000, where a local authority was held liable for allowing a nuisance on land it owned, and in Tetley versus Chitty 1986, where a council was liable for authorising a nuisance through a lease. And in Barr versus Biffa Waste Services Limited 2012, the Court of Appeal held that compliance with environmental permits does not protect against a common law nuisance claim. Yet you've repeatedly stated that the Environment Agency has not found a breach the council cannot act. That is not the law. So, Councillor, on what legal basis do you now deny responsibility for a nuisance the council knows about, profits from, and could lawfully stop?
Thank you. Thank you, Dr. Neil. Councillor McKay, would you care to reply to that?
Thank you, Mr. Mayor, and thank you, Dr. Neil. I'm not a legal person. That's not my trait. I will, however, say that we have taken legal advice and we continue to take legal advice. We are acting in the best interests of residents of Wyre. I can't disclose those conversations, but we are acting in the best interest in Wyre, and we are going along without the legal advice that we are given. But I would challenge the fact that we're making a profit on the site. We have officers now who are dedicated to this around the clock. It is costing us a huge amount of money. We're not profiting from the site at this point.
I would like to request a written response to that question, please.
Yeah, you'll receive
A
one,
proper
that's fine.
written response. Thank you.
Thank you, Councillor McKay, and thank you, Dr. Neil.